SJC-13330, Frederick Douglas Greene and another, v. Philip Morris USA, Inc.
Okay, Attorney Chesson.
Good morning, Your Honors, and may it please the Court. Scott Chesson from Shakardi for Philip Morris. Your Honors, the plaintiff prevailed in this case on a claim for conspiracy to commit fraud, even though she testified that she neither began smoking as a child nor continued smoking as an adult because she was misled by anything that the defendant or an alleged co-conspirator said about the dangers of smoking. The jury found in her favor anyway, having been given the exact instruction on causation that this court held 2 weeks after judgment entered in this case was sufficiently confusing as to potentially encourage jurors to find.
Can I ask you the issue about waiver? So I haven't read all through these transcripts, but I started reading the jury instructions last night.
Yes.
And there's a fight about causation on the warranty issue.
Yes.
And then, were you trial counsel?
I was. Well, I was the lawyer at the charge conference.
So I take it this is you. I have but one proposed edit to the previous page 20. Okay, Mr. Chesson. In the third element, yeah, the very last clause, namely that it was in the third element. You have only a minor, I guess when I copy this, it doesn't, but you don't, you reference a substantial contributing cause, but that's not your problem. You only have a problem with a plural versus a singular.
I agree with Your Honor. I know exactly where you're going with this. And I assume the question is, was I indicating to Judge Kazanjian that I acquiesced in the substantial
More than that, you weren't at all concerned about it.
And I understand the question. Look, what I invite the court to do is to read that colloquy in the context of the entire charge conference, which began with a 10-page discussion over two things: whether the court should give the but-for causation instruction that was word for word the instruction that Your Honor discussed in duel, and also our objection, which we made in great detail. But
the conversation, you guys are talking around each other also, because she says, I'm telling them that that cancer has to be caused by the smoking. Right?
Correct.
I'm making findings on causation, and then you guys get into a but-for substantial contributing cause. But then conspiracy is much more, and also this is a case in which Philip Morris made the product. Mm-hmm. They did the marketing.
Yes.
They created the low-filter cigarette. They, you got all the findings on the 93A claim. Right. This is not a case of what caused this. It's really...
And that's precisely my point. And the plaintiff and the plaintiff's amici make a lot in the briefs of the fact that this is a cigarette case and it involves multiple exposures to a toxic product, and isn't that similar to... No,
I'm not going there toxic toward who's responsible. I'm just focusing on the fact that a couple of things. One, the judge feels like the causation issue is addressed by other parts of her instruction. It may be confused by her substantial contributing factor discussion, but you win that claim. You win on the one you lost, you actually won on, and now we're just dealing with the conspiracy, which is incredibly complicated and different from a normal, simple negligent tort, and you have no objections to the instruction on that.
And here's what I'll say, and I would direct the court back to that opening discussion, and I've written down here, I remember precisely what you're talking about, where the court says, I don't see how my instruction is misleading because I tell them it has to be a cause. And what I said to Judge Kazanjian was two things. I said, I want to make sure that the jury understands that the baseline has to be but for, and only some but for causes are substantial enough to be legal causes. And that's when the court says, I don't understand how I'm not telling them that. And the next thing out of my mouth was, absent some sentence that says, if the harm would not have happened anyway, the defendant is not liable, the jury could conclude that even if the harm happened anyway, the defendant could still be liable.
What cause of action are you talking about when you have that
We
conversation?
we were talking about the breach of warranty, but what I will note is that in 10 pages of transcripts, not once out of my mouth do I say the word warranty, do I say the word
I
defect.
know that, but what I'm getting at
Yes.
is conspiracy is what we're looking at here.
Absolutely.
And you need to hone in to Judge Kazanjian on why but for is better than substantial contributing cause on conspiracy, when conspiracies are combinations of persons acted pursuant to an agreement to injure the plaintiff. A conspiracy is different than a breach of warranty. It warrants, it warrants a specific discussion about whether, and you may be 100% right, I obviously don't agree, but you might be 100% right, that conspiracy should also be but for. It's a separate analysis, and that wasn't made to Judge Kazanjian.
And what I'm saying is this. We submitted a set of written instructions that for each of the causes of action, our set of written instructions and the plaintiff's set of written instructions defined causation using the pattern instruction the first time it came up, and then referred back, and our set of instructions used the words, alternatively used the words cause, was a cause of, resulted from. Plaintiff's set of instructions continually used the substantial contributing factor language. And once we objected to the use of substantial contributing factor, made all of we talked about the 2 fires and the 2 hunters, and we read to the judge the comment from the third. Excuse me?
You were prescient on the issue, but.
And my point is this.
By the way, one thing I really want to do is,
yes.
The big money is on 93A, and I got bigger problems with your argument on 93A, so I just want to make sure you realize we got questions there, too. Okay.
I'm here as long as you want to keep.
So I just wanted to give you an opportunity to finish your sentence. Is your point really that having gone back and forth about but for and substantial contributing factor, and having lost that battle, or at most have Judge Kazanjian put a point on it and say, I don't think I agree with you, that at that point she was on notice that you guys were going for but for, and that you were hearing loud and clear, she didn't want to hear it.
Look, I don't mean to cast aspersions on Judge Kazanjian. She was incredibly patient with us. That charge conference in 2 sessions went on for 5 hours. And at one point, about 10 minutes into this discussion, she said, counsel, you're trying, or I think I said, it appears to me that I'm trying the court's patience. And she said, yes, you are. At multiple points toward the end of the charge conference, the next day when she gave the charge, she said, anything you've argued, you don't need to argue again, you're preserved. The point of waiver analysis, and I say this with all due respect to your honors, you're the ones who make the rules, is you don't want to incentivize smart litigants not to point out an error, let something happen, and then come complain about it on appeal. On the other hand, if you have made your point, the futility cases that we argue in the briefs say, if you have made your point clear, and it is clear that you've lost, that 5-hour charge conference could have been a 10-hour or a 15-hour charge conference if every one of the dozen similarly situated issues we needed to repeat over and over again. And I would respectfully suggest that no reasonable reader of that transcript could think that if I had made that same argument in that level of detail,
I would push back on one point,
absolutely,
which is the fight in duel aside. The judge keeps emphasizing substantial contributing cause. She doesn't use the word, she uses the word factor a couple of times, but she keeps emphasizing the cause of the cancer here is the smoking Marlboro Lights. When we read her 93A decision, she's, again, one time she strays into this, but she's very focused on the fact that the deceitful acts, in her words, that Philip Morris did caused her to keep smoking Marlboro Lights. And that caused her cancer. So she's not caught up in sort of this idea that, I mean, again, Justice Lowy and I will disagree on whether but for should have been in the first part too more expressly, but her 93A findings are really not affected in by the substantial contributing factor
Well,
stuff.
I may agree to disagree with Your Honor
Go
on
ahead,
that
yeah,
point, but if I can back up, I mean, just the structure of where we are here, I've got a sufficiency argument, putting aside the correctness of the jury instructions. It is our respectful contention that the evidence was simply insufficient under either standard of causation.
No, I know your argument is something to the effect that she smoked knowing that it was dangerous, but she liked the ads. And the ads were, it's Marlboro country, she liked the outdoors, she liked the cowboys.
To put a finer point on it, if we're talking about 93A, no, that's not our argument. 93A involves acts that are taken by the defendant sometime after the effective date, which is in 1979.
Right.
There are no television ads from 1971 on forward. Right. But the sole basis of Judge Kazanjian's finding of fact on 93A is that well after the Marlboro country, she says, Mrs. Greene was misled by Philip Morris into believing that Marlboro Light cigarettes were less dangerous than Marlboro regular cigarettes. And that was a cause of the cancer. And our argument is that second half of that conclusion is unsupported by any evidence whatsoever because Mrs. Greene testified affirmatively. These are not concessions given on cross-examination. This is in response to questioning from her own lawyer. She says, I thought they were less bad. I smoked them because I thought they were healthier, but I knew they were unsafe. I knew they could cause cancer, and as a result, I kept trying to quit consistently the entire time I was smoking.
But doesn't she also, again, and this is going to be in the light most favorable to the
Absolutely.
other side, doesn't she also say, look, I thought they were better than the regular Marlboros. No one told me, I have there's sort of a multiple misrepresentation. I know you talk about them as omissions versus affirmative misrepresentations, but doesn't she, when we go through this, reading it in the light most favorable to her, say, they're lights, they're less dangerous.
I'll give her more than that, and we said this in the briefs. This was a disputed fact at trial, but I think the evidence is sufficient to allow a reasonable jury to conclude that Mrs. Greene was misled about whether Marlboro Lights are safer than Marlboro regulars. But that's element 1 or element 2. Element 3 is, did the deception, did the reliance on a false statement cause the injury? And our contention is the only way to read the testimony, because it's her affirmative testimony, is that she might have been smoking Marlboro Lights because of a fraud, but she wasn't smoking because of a fraud. She said, I was smoking that whole period I smoked Marlboro Lights. Despite repeated efforts to quit, I was smoking because I couldn't stop.
Is in the light most favorable to the plaintiff
Yes.
on the 93A, could the evidence be taken that, well, I thought the lights were better, so I really didn't work as hard at it.
I'm glad you asked that question. That is the linchpin. I would say the sole basis in Judge Kazanjian's order for finding causation. There's one sentence in there. She said the evidence was sufficient, or I am convinced that she was less motivated to quit, and there was evidence that people are less motivated to quit if they believe that the product they're smoking is healthier. And with all due respect to Judge Kazanjian, I don't think the evidence can possibly support that conclusion. There was evidence from testimony from an expert witness who had never met Mrs. Greene, who didn't know anything about Mrs. Greene, hadn't read her testimony, who said that, yes, some people, when they are smoking what they perceive to be a healthier product, are less motivated to quit and smoke that product instead of quitting. The testimony from Mrs. Greene, again, affirmative testimony from the plaintiff in this case was, despite thinking they were healthier, I kept trying to smoke. I kept trying to quit. Obviously, Your Honor should read the entire colloquy.
But I think the trial judge does, she's very explicit that addiction means different things, that, if you think you're swallowing poison versus you think you're swallowing something that's less dangerous, it affects your will. I mean, she's got a lot of this in here, right?
I understand that. I would direct your honors to the following. Obviously, read the whole, back and forth, and the direct and the cross and the redirect. On page 70 of the 5th volume of the record appendix is the recross of Mrs. Greene. It's Philip Morris. On redirect, Mrs. Greene had testified, because they're talking about comparative negligence, I don't believe I bear any responsibility for my injuries. And so on recross, counsel for Philip Morris asked her, why? What do you mean by that? Why do you think that you are not responsible? She said, well, I started when I was a kid. I switched to what I thought was the healthier alternative. And even after I switched, I kept trying to quit. She said that very definitively, and she had earlier in her testimony said, she'd given great details. I ripped up my cigarettes, I dumped the tobacco out, I threw them away, I used cherry lozenges, I used the gum, I used the patch. My point is this.
Yeah, but one of the reasons she doesn't realize that she's actually, again, the conspiracy theory, she doesn't realize that she's actually consuming as much nicotine when she's doing that.
But
right?
she says, I knew they could cause cancer. And remember, every package of Marlboro Lights that she smoked had a warning label on it that, at least after 1985, said this can cause cancer. And before 1985 said the Surgeon General has determined that these are hazardous.
But Aspinall says that if you're deceitful, that's not protection, right?
Well,
Aspinall leaves it open that if you've engaged in sort of this pattern of deceit, they can still sue, right?
They can still sue, and Aspinall was a consumer class action seeking a refund of money for what the plaintiffs alleged was the difference in the market price for what but even in the Aspinall decision, it expressly says if this were a personal injury action, the question of causation might be different. And one way, the cases on 93A are very clear that a plaintiff has to prove that the violation caused the injury. And so when the allegation is the violation is a conspiracy and my injury is I've been personally injured, I think it is not a far leap to say that the plaintiff has to prove.
But the trial judge, again, she makes findings that got to be clearly erroneous, that smoking Marlboro Lights caused the cancer, and your client's deceitful acts perpetuated her continuing for years and years to smoke Marlboro Lights.
And it's that last point on which I take issue, not as a matter of persuasiveness, but as a matter of sufficiency of the evidence. And it ties into the conversation we had at the beginning about what the causation standard is. You have to look at the hypothetical what if. Yes, the judge made a finding that she was smoking Marlboro Lights because of a deception. But the question is, what would she have been doing in the alternative universe where she hadn't been deceived?
Well, the judge, and again, I may be confusing what she says because I read your back and forth with her on jury instructions last night, but the judge says addiction's complicated. Her willpower might have been different. I don't know if she finds this in her decision or in the back and forth with you.
I'm not actually sure either, but I know there is there's a discussion in the 93A order in which the judge says people are less motivated to quit if they are addicted and they believe that they're smoking a healthier product. And what I'm saying is that is a conclusion that cannot be squared with the affirmative evidence that comes from the plaintiff.
The problem from your perspective is not
It appears I have several.
the law that's written on 93A. She says cause. It caused. It's whether or not there's support for that determination at the trial.
Right. I mean, look, I'm making two nested arguments. I'm saying that there was insufficient evidence from which a rational finder of fact could have found that there was a cause. And I'm saying, even if I'm wrong about that, at least with respect to the jury findings, the jury was misinstructed on what it means to be
Talking on
caused.
93A only. There's no problem with her determination on causation on 93A as a matter of law. The question is whether the record supports that.
Correct. Well, I will say, Your Honor is correct. Our argument on 93A is that there's insufficient evidence. I will say, though, that if we get past waiver, if Your Honors believe there was an error in the jury instructions and the common law wrongful death jury findings on conspiracy need to be retried, I do think that the prudent course would be for Your Honors to vacate the judgment in its entirety and send it back.
She says it caused.
She did, but two things. Number one, I mean, I was watching the previous argument where Your Honor said, absent some, there's case law that says absent some contrary indication, you assume that the judge instructed herself correctly on the law. The contrary indication in this case, I think, is the judge's very firm holding with respect to the instructions to the jury that all that was required was substantial contributing factor causation rather than but-for causation. But beyond that, the judge does make a number of record-supported findings of fact, which don't depend on the jury verdict. But when she gets to the end, she says, I am expressly adopting the jury's measure of damages and using that as the basis to impose treble damages, which again is the judge's prerogative. But in circumstances where the judge has taken an advisory verdict from a jury and applied it on 93A rather than making independent findings, if that jury verdict goes away, I do think that...
Yeah, but she's made her own independent findings on causation. Whether the amount of damages she framed it at, I don't quite see that point. But
well, I will say this. I see, and Your Honors have very generously allowed me to keep talking past the red light.
But not as long as Judge Kazanjian did, please.
We did. Mr. Rayner was with me at the charge conference. We did a lot of talking throughout this trial, and the judiciary has been very patient with us. I will. Before I sit down, I would be remiss if I didn't say something about the interest issue, which I suspect but don't know might be the reason that I'm standing here rather than somewhere else in this building for this case. The jury in this case found that Mrs. Greene sustained about $2.5 million in economic damages as a result of this tort. If we were to pay the judgment tomorrow, we would be paying close to $16 million in interest.
can I ask you about, and I understand that this seems to be baggy thinking on the part of the legislature, that they could easily draft a much better statute.
And they have, with respect to the Commonwealth, with respect to medical
But
malpractice.
they haven't. And at one point they adjusted it upwards because inflation, right?
At 3 points they did.
Right, yeah, so they do that multiple times, but they haven't sort of made the downward adjustment that you want.
In
It has to-
41 years.
Right, no, and I get it, but no rational basis for this thing?
Look, here's my point, and I'm not running from the standard. I understand rational basis is a tough road to hoe. But we cited to Your Honors in the briefs at least 3 times in the last century where this court has said a statute that was constitutional and rational when passed becomes irrational and unconstitutional over the passage of decades when circumstances change. It happens on occasion. It hasn't happened in the case of...
Has there ever been, and again, I have confidence that this is well argued and well researched, has there ever been a case, I mean, there are interest rates out there, I assume as baggy in their thought process as Massachusetts. Has anyone ever declared one of these interest statutes unconstitutional?
There's a trial judge in Illinois who just a month or so ago declared the Illinois 9% fixed interest rate to be unconstitutional. It was based on that.
When does this become unconstitutional?
At the point where it outstrips the purpose of the statute or any permissible purpose of the statute so much as to become punitive. I can't tell you what the
Well, that's the problem.
what the precise
right,
number
so become rational basis point. Like
Right.
if it was 7%, could you make this argument?
it would be closer, but even look.
Does it
If
have
the
to-
Commonwealth
does it have
had
to
been-
track inflation?
So
I
if
mean,
the
does it have
Commonwealth
to-
had been the
Does it
defendant,
have to be as sophisticated as the feds? Or
absolutely not. Look, the general court passed this statute initially in the 19th century at some point, and it had no interest rate at all. It was adjusted upward in 74, in 80, and in 82, and then they stopped. Right.
If we concede, for the sake of argument, it's a bad statute. All right. and it's
We're
a-
all on the same page, and I imagine plaintiff is as well.
All right, but it is the statute.
I don't think
Wait,
I don't think the plaintiff thinks it's a bad
Perhaps
statute.
not. I think
I
they
think
like
they're
it.
enjoying
I would-
this. In the response to we have to pay this might be then stop causing so much damage. But that's might be their argument. So if it's a bad statute or bad policy, what I'm trying to struggle with, when does it become a due process violation? At what percentage? How are we supposed to measure
Here's
that?
what I know. Prejudgment interest baked into this judgment was about $6.8 million. Had it been at the rate that the Commonwealth pays, it would have been 48,000. 48,000, not 480, not 4 million. It would have been 48,000. What I know is that the mismatch between what everyone else is paying in interest and what tort defendants
So
in
we
the
tell the
Commonwealth are
legislature, this is unconstitutional, it violates due process, there's no rational basis, fix it. And we're not going to tell you the number?
Oh, precisely. I mean, I want to be clear about the relief that we're asking for. We are not asking for this court to substitute its judgment and to become legislatures. What we're saying is the court has the power to declare the portion of the interest rate statute that sets that rate at 12% to be unconstitutional, vacate that portion of the judgment, send it back. We can do it the way it was done before 1974. We can have a
You got to remember,
hearing.
these are being done in the Commonwealth every single day. So we're going to we'll put this into an emergency crisis for the legislature, right? Yeah.
Which I don't necessarily think is a bad thing.
No, I'm not saying
And
that.
here's what I know. We cited to your honors a case called Vigant or Vigiant. It's an ancient case. It's from 1927. It was about telegraph poles. The general court passed a law in 1851. Said anybody who's injured by a telegraph pole, the telegraph company has strict liability regardless of fault. And that was a perfectly acceptable exercise of the state's police power. But by 1927, there were telephone poles and there were electrical poles, and if you got hurt by one of them, you had to prove negligence. And a telegraph company sued, and they said, this statute makes an irrational distinction among otherwise similarly situated entities. And the court, I would urge the court to read Vigant and the several cases that cite it in different contexts that we also cited in the brief. And the court says, when the general court chooses to write a law that is rigid and inflexible and does not account for changes in circumstances, it runs the risk that over time that statute will become so outdated as to violate the Constitution, and it struck down that statute.
What
This
is
statute,
Philip Morris's own return on investment?
I didn't hear you.
What does Philip Morris earn on its return? What's the interest
I
rate?
mean, I don't know, but I take your Honor's point that it is possible that this defendant might make a good living and might be able to put its money to good use. But remember what the purpose of the interest statute is. The purpose of the interest statute is not to punish the defendant. I mean, this court has said this half a dozen times in the last 20 years. It's to compensate for the lost
I
value of
understand
money.
the purpose of, one of the purposes of the interest rate. I'm just wondering why it's irrational in this context.
Because if the purpose is, as Your Honor is implying, which is to punish the defendant, to give the
Not to
defendant
punish
its
the
due,
defendant, but to have the plaintiff the ability, give the plaintiff the ability to earn as much as the defendant might earn on the same dollar.
Well, I have a few responses to that. The first is that we don't know. That may or may not be accurate in terms of numbers for this defendant. It certainly isn't, I would say, for the vast. There's a reason Your Honors haven't gotten this issue before. It's that there are very few entities who are going to take this issue this far, because I would submit that for most tort defendants, the prospect of crushing interest, and crushing being a lot less than what the interest would be in this case, provides a strong incentive to settle cases or to, not appeal cases that would otherwise not be settled and would otherwise be appealed.
But does that provide somewhat of a rational basis for it? Meaning that if you got a good appeal and you're sure you're going to win, go for it. But if you got a loser, we want you to get it over and done with.
I would direct Your Honor to the discussion of a similar topic, and I think it was the McAvoy case. It's one of the cases, not on this topic, but tangentially on interest. It was the case where the court said prejudgment interest doesn't apply to punitive damages under 93A. And the court dealt with this and said, just because it may, 93A with the prospect of punitive damages already incentivizes defendants to take a good hard look at their case before moving forward. But to add interest on top of that penalizes the defendant in a way that doesn't add to the...
Remember, a lot of cases don't have 93A claims. I mean, nowadays they mostly do, but...
Right. I understand, but my point is, if that is the purpose of the statute, to move things along quickly in the judicial system, I think it is irrational to do it by placing the onus solely on the defendant, not on the plaintiff, not on the court system. This case was filed in 2015, tried in 2019, at least a year of that delay. It was legitimate, but we were supposed to try this case in 2018, but Mrs. Greene got sick and wasn't able to participate in the trial, and there was another year. We got a jury verdict in 2019.
There's kind of an irony that she couldn't participate because she was sick.
Oh, I'm not, look, please don't misunderstand me. I am not saying that there's anything that the plaintiff has done to unduly prolong the proceedings. My only point is there are things that are outside the defendant's control. It took 2 years from verdict to judgment because of COVID, because we were figuring out how to litigate 93A over Zoom. And so if the purpose is encourage defendants to speed things, encourage things to be sped up, I would submit that that is not a rational or fair way to do it, to put the onus on the defendant. So anyway, I see that I've now gone double.
Any way to stop the interest?
I'm not aware of one.
Could you put the money in escrow, for example, and stop? I just don't know.
I don't know the answer.
Is there any
the answer is no.
self-help that the defendants can engage in?
Isn't there like an offer of judgment that you can make to stop the interest from accruing? Is there something the defense can do?
I will confess ignorance on this point. I believe the answer is no. I mean, we could pay and settle and stand down on an appeal.
No, but short of that.
I'm not familiar with a mechanism that
Seems
allows
like
us.
something you might want to get familiar
I'm
with.
saying it is something we might want to look into because, I mean, and that's the point. The amount of interest, I'm talking if we paid it tomorrow, not if we waited 130 days and then a mandate and then, my God, a cert petition. You know, if we paid it today, the amount of interest would be the same as what Judge Kazanjian found was the maximum punitive damages available under 93A for this conduct.
Okay, I'm gonna,
It's time for me to stop. Thank you, Chief.
thank you so much. Okay, Attorney Bogner now.
May it please the court, your honors, my name is Michael Bogdanow. With me is Andrew Rayner of Public Health Advocacy Institute, and along with other co-counsel, we
Counsel,
represent.
do you know the answer to my question? Is there anything that the defendant could do in this situation to stop the interest from accruing?
My memory is that the procedure you're referring to is Civil Procedure Rule 68, offer of judgment. But again, I didn't come too prepared on that issue, but that's my memory, is that the Civil Procedure Rule 68 covers that. As you know, we represent Patricia Greene and the estate of her deceased husband, Frederick Douglass Greene. And I'd like to start, if I may, just a couple minutes on my brother's sufficiency of evidence argument before we move into dual and prejudgment interest, because it's very important. We contend there was plenty of evidence to support both the 93A findings as well as the judge's denial of the JNOV motion. Our client at the age of 13 was the target audience for the massive advertising. She fell for it. She became an addict early on. She then switched to lights at a relatively early age, and she switched to lights, in her own words, because they were a healthier alternative. Low tar meant less of the bad stuff. Most importantly, she found what she was looking for. And that is exactly the message that Philip Morris gave. Philip Morris knew that smokers were switching because, this is Philip Morris's words, they thought they were engaging in good health behaviors. It was an alternative to quitting. So she fell for that. She believed that they were healthier, and she was deeply addicted to nicotine. So yes, she kept trying to quit, but she failed to quit. And this court in Evans said that nicotine addiction has to be part of the jurisprudence of these tobacco cases. She wanted to quit, yes, but she couldn't quit because she was addicted, and she kept buying Marlboro Lights because she thought they were healthier. That's a fact, and that was in evidence. And the fact is that it's the Marlboro Lights that eventually she succumbed to when she contracted lung cancer. And so they sold a product, they misled the world about it, and she fell for it. The evidence supported the jury's verdict, and the evidence supported Judge Kazanjian's
Although the jury's verdict is more complicated, right? you lose on negligence, you lose on warranty, you win on this esoteric conspiracy theory, which is inconsistent, by the way, with everything you just said, which was Philip Morris did this, Philip Morris did that, Philip Morris, and it is, Philip Morris, I mean, I don't find this really that complicated on causation. Philip Morris made the cigarettes, did the marketing, built, did this, didn't tell everybody that they're actually, the FTC is wrong, that you just smoke more, you breathe more deeply. So Philip Morris is definitely the cause of all this. But then you went on this conspiracy theory about other people, which she's probably completely unaware of. And that's, to me, why if there's not waiver on the first part, I can't figure out exactly why there isn't a little bit of a problem here on the first one. I'm not troubled by the 93A, but finding that the conspiracy is the cause of her injury and cancer and all the problems, when actually it's Philip Morris and all the things that Philip Morris did by itself that seems to be the central focus. And there's no but-for causation instruction on the conspiracy part of this, which, again, it's like this esoteric side claim that involves everybody else when Philip Morris is really the bad guy here.
It's very explainable, Your Honor, and I think the jury's decision, which was that Philip Morris negligently marketed to minors, but that there was not causation on that claim. They found the negligent marketing, but they did not find causation, but they did find that the power of the conspiracy was really what caused the harm. It's perfectly explainable. The industry...
Explain that to me. When Philip Morris builds the cigarettes, the testimony is she's swept in by the marketing about Marlboro Country, and that she's not aware, she hasn't read any of these reports, right, from the Tobacco Institute, whatever they're called. It may all be waived, and that may be a straightforward way for you to win, but I don't understand. Don't we have to find that this conspiracy itself caused this injury? And that's a complicated analysis.
It's complicated, but the industry was part of this lights low-tar fraud. It wasn't just Philip Morris, and the jury understood that. Let me just give you a few of the references for that. The low-tar fraud really was a way to alleviate consumers' concerns about health. It actually began evolving at the same time the conspiracy began evolving. That testimony,
but again, separated out from the fact that Philip Morris is trumpeting its low-tar cigarettes. Philip Morris is doing this, and Philip Morris is creating the cigarettes, and Philip Morris knows that people tugging on those are tugging more than the FTC thinks. How is that? Don't we have to separate that out from this conspiracy issue?
I think, and again, we'll get into this on the dual side of this as well, but I believe you're still on the factual evidence to support it. And as to the evidence to support it,
no, I'm not. No, actually, I'm totally not on the. I believe that this whole Philip Morris is involved in this enormous deceit. This Philip Morris is part of this deceitful conspiracy too. I get that, but I don't understand. Doesn't the jury have to make some kind of that this added something to it?
And the jury,
especially when I've got verdicts in favor of Philip Morris on warranty and negligence, which makes it sort of strange.
And that's exactly it. The jury understood this was the conspiracy. This was just like what Judge Kessler in Washington, D.C. in the landmark case of U.S. versus Philip Morris, then affirmed by the D.C. Circuit, what she found as well. The low-tar fraud was an industry-wide sensation. By 1981, every one of the conspirators was on it. They were all portraying these low-tar cigarettes as safer for you. And that's because they needed to convince the public, and it worked with the public and with Patty, that these cigarettes were better, they were healthier. And it was giving them, and again, in their own words, it was reassuring them that you could smoke without the health risks. It was serving the quote-unquote most important purpose of the conspiracy, to free smokers from the guilt they felt when they smoked. So what the jury saw was that this was the entire industry that got onto this. Eventually it became illegal to use the word lights with cigarettes. The whole industry was on this, and that's why it is part of the conspiracy, and the jury felt it was that power of the conspiracy that caused the harm, and probably felt that if Philip Morris had told the truth and broken out of this conspiracy and said, you know what, these low-tar cigarettes aren't any safer for you than conventional ones, which they knew, and behind the scenes they said, that would have solved it. So there was plenty of evidence on that. Yes?
I'm sorry. Can we just talk about whether there was a waiver or not?
Yes.
On the conspiracy, on the causation standard?
Yes, Your Honor.
Because what Philip Morris is saying is, if you just look at the transcript and the discussions, it's palpable, it's obvious that Philip Morris is talking about but for as it relates to the entire case and all the causes of action. On the other hand, they do not, in the context of conspiracy, request but for. And conspiracy, by its nature, whatever you think of but for a substantial contributing factor, conspiracy, unlike the negligence cause of actions, for instance, involves more than one entity. And so maybe it should have been but for, but it required a separate analysis.
Philip Morris actually, in its brief, said, well, we argued but for as to warranty, and then we told the court that we wanted it to apply to all the other claims. That was in its brief, but I noticed there was no reference. So I spent hours looking for that reference, looking for the moment when they say, we want but for, which we put in the instructions for negligence and warranty, we want it to apply to all the claims. I spent hours to see this unreferenced
Let's say
remark,
you,
but
let's say you didn't miss it.
They didn't.
Let's say that you didn't miss it. It's not there. Is there something about the entire argument that says at this point, you can't now make an argument on conspiracy? It's futile. It's just not going to work.
The reason that's not this case, Your Honor, is that they put in conspiracy instructions, which were accurate. They were accurate under the Restatement Second, Section 876, which is the conspiracy section that was not revised in Restatement Third. They put in what they wanted. They put in instruction requests, which were for conspiracy, that the conspirators had to have performed acts which caused Mrs. Greene's cancer, that the cancer had to have resulted from the power exercised by the conspiracy. And they got the exact instructions they asked for. This is way beyond even just a simple waiver. They asked for instructions on conspiracy. They did not ask for but for, and they got the instructions they asked for.
How does the substantial contributing factor get into the conspiracy instruction?
So Judge Kazanjian gave the precise instructions that my brother requested, verbatim, on causation. She didn't give but for, my brother didn't ask for but for. And then she gave the substantial contributing cause instruction, and she defined it very narrowly and very carefully. She said, to be a substantial contributing factor in causing Ms. Greene's cancer, Ms. Greene had to have, I am quoting the instruction, reasonably relied on a false statement and was injured as a result. She couldn't have been more explicit with this jury that they had to find causation. They even had to do more. They had to find it was a cause, and they had to find it was substantial.
So so essentially, although you guys went back and forth, these two gentlemen went back and forth on whether you would do add but for to substantial contributing factor. You talked about that in the instruction. She actually sort of did that, is that what you're saying? That she put in without using the word but for, she put in she made it clear that that was essentially a but-for addition to it.
She gave the exact instructions that this court actually would have wanted based on the principles of dual, that you have to prove that the conduct was a cause. She told the jury that, and the jury got it. And that goes back to your question, Your Honor. The jury didn't feel that that individual, outside the conspiracy, individual conduct of Philip Morris was enough to have done this. It took this entire industry lying to get to the causation. And again, in conspiracy, as I've said, the but-for instruction generally does not apply. And that's even true under the ALI's restatements. There was nothing under the restatement third.
How does the restatement third, the restatement third doesn't have, they don't do what Judge Kazanjian did, which is put in the substantial, because they moved away from that language. But the other instruction she gave was what do they do? How do they deal with the sort of additional language in the restatement third?
There are two ways I would address that. First of all, they don't touch conspiracy law. They just don't touch it. It's in restatement section 876, restatement second, Your Honor, section 876. It's there. The comments to that make it clear. It's substantial cause, not but for. So she addressed it even under the third restatement, section 27.
Restatement third, again, I'm going to go back and read it, but restatement third, when in the conspiracy discussion, cross-references, has a reference to the substantial contributing factor as still being appropriate, even though the restatement third wipes out substantial contributing factor, it still maintains it on the conspiracy count expressly, or are you just reading that into it?
My reading of sections 26 and 27 of the third restatement it just doesn't touch conspiracy law. It doesn't mention it. It doesn't address it.
So it doesn't weave back in. It doesn't. But again, restatement third spends enormous amounts of time wiping out the substantial contributing factor stuff. It doesn't sort of opine that it's still okay to do substantial contributing factor in conspiracy, or it doesn't discuss it at all.
Your Honor, especially when you move into section 27 of the restatement third, it makes it clear that, and I think conspiracy falls within this, although it doesn't touch conspiracy. That was already addressed in the second and not revised. It makes it clear that when there are these multiple causes, which is almost inherent in a conspiracy, that you have multiple actors and multiple forces, then you have to instruct that that the conduct of the defendant has to have been a cause. It couldn't be clearer, which is exactly what Judge Kazanjian instructed. And some of the notes, as well as the toxic tort conspiracy cases and notes, make it clear that these multiple cause, we won't even say multiple factor, multiple causes, you can't immunize a defendant just because it's also possible that addiction or that
you can have multiple but-for causes. That's not a problem.
You can have multiple but-for causes, and then what the jury needs to know is that this defendant's conduct was a cause of the harm, and it couldn't have been clearer from the instructions.
So to be helpful because we're not only deciding your case, but if we made clear that the language Judge Kazanjian uses, not the substantial contributing factor language, but the language she uses about causation is the appropriate additional language in a conspiracy case, that makes sense to you. That's the proper interpretation. That she should give the standard instruction plus that line without getting into substantial contributing factor.
Her instructions in this case were perfect, Your Honor, and if that's your question.
Well, no, that's not my question. My
If
question
you're saying,
is,
what if you
my
left out
question
substantial factor?
I don't think the substantial contributing factor language is helpful, but we also need a clear standard going forward. If that language is removed, it avoids this fight and confusion, but it will also make clear that you have to prove it's a cause. In addition to giving the standard conspiracy language, is that sentence adequate to solve the causation issue?
I do follow you, Your Honor.
Yeah.
Let's put substantial factor on the side and focus just on the instructions she gave. They were perfect. She told the jury they had to find that the conduct of Philip Morris as a conspirator caused the harm. They were perfect. They were exactly, precisely, verbatim what my brother requested. Of course, he didn't object to them. He asked for them, and he got them.
Wait, so you're saying your opposing counsel asked for the following: in pursuing such a conspiracy, Philip Morris and the other tobacco companies performed acts which injured Mrs. Greene, namely such acts were a substantial contributing factor in causing her cancer? You're saying that if I look back at what they requested that?
I'm saying that her causation instruction, I was asked to put substantial factor aside. This is, I'm going to tell you what Philip Morris asked for. Philip Morris said, as to the concerted action theory, causation is proven if conspirators performed acts which caused Mrs. Greene's lung cancer. As to power of coercion, causation is proven if her lung cancer resulted from...
Yeah, so that's the second theory of conspiracy. I'm going to the first theory of conspiracy, where she actually says substantial contributing factor in causing the cancer.
So I was trying to answer the question that, let's say we move that aside.
Yes.
Now, if we want to bring that back, no, my brother actually did, if you look at the colloquy that he wants you to read carefully, he actually did want substantial contributing factor. He wanted but for and substantial contributing factor.
Which is what she gave.
Which is essentially what she gave.
Okay.
So yes, but she also narrowly defined substantial factor as reasonable reliance on a false statement and injury as a result. So
No, but now you're mixing up the two theories of conspiracy, which I think is wrong.
Well, I'm bringing the substantial factor because that's where she said it. And so that's where she says to the one of the two theories. You're right, Your Honor. But she narrowly defined
So
it.
if I look at the record and I let's just say I don't think there's waiver, and the second theory of conspiracy was accurately instructed as but for, but the first theory was not, what do I do?
Well,
I have
first
to
of all,
send it back?
well, first of all, the jury found liability on both theories.
Yeah.
And second of all, I just don't see, and I guess this gets back to the previous question, I just don't see how her telling the jury that they have to find causation on both of the two theories, and then explaining substantial factor could possibly be grounds for sending it back, Your Honor. It just, there was no confusion, and the proof is in the pudding. The jury was nuanced in its causation findings. If the concern is jury confusion, we know they weren't confused about causation because they thought it through, and that's why there was individual negligence on Philip Morris's part, but no causation. This was a jury that was thinking carefully about causation, and I don't think there's any showing here that there was jury confusion. And my counsel...
Can I ask, I'm now a little confused, and maybe Justice Wendland's ahead of me, though. So there are two different conspiracy theories. Is the substantial contributing factor given in both instructions? It's given in both.
My memory is that she included in both, I believe.
But she also includes a causation instruction in both? Separate from the substantial contributing factor thing.
Correct.
So even in dual, we say that the problem with the substantial contributing factor is when it's given without the but-for instruction. Here, though, it sounds like we've got a causation instruction in both of these. So even it may be consistent with, I know you want dual limited, they want it expanded, but it sounds like it may be that the causation instruction she gave on both conspiracy theories removes the danger that we identified in dual because it puts in a causation requirement so that the jury can't just skip the causation requirement.
That is our position, Your Honor, precisely.
Okay.
I think, unless any further question on that, I should spend at least a few minutes.
Yeah, could you talk about, so the interest, I mean, if we're Argentina, 12% makes a lot of sense, but we're not Argentina. And there's a big differential here, and we can't punish appeals, right? We don't want to punish, because we're going to punish meritorious as well as unmeritorious appeals. So how is a 12% interest in a low interest environment, a low inflation environment, like is what we are now? So, although we're in a, times have changed, but a year or two ago, 12% was crazy compared to what, the interest rates were. So what do we do here? And why is it a rational basis for this? Because it's a really sloppy, baggy statute, but.
The rational purpose is it compensates for loss of use, and I'll get into what that means exactly. It avoids market fluctuations, which is a rational purpose, and it promotes administrative ease in calculation. Now, why is it a fair, or it doesn't even have to be fair, it just can't be irrational? Why is it a rational statute on the interest? Well, the prime rate, which my brother raised in his brief, it's not the only indicator of what would have happened with that money. For example, that money could have been invested in the long-term Standard & Poor, and it would have been about the same as explained in our brief. It would have been about the same as 12%. It would have been about 11.5%. Even better if it was invested in Philip Morris on the Standard & Poor, then it would have been skyrocketing. She could have invested it in real estate. There are a number of things that could have happened with that money. The 12% is substantially lower than what plaintiffs have to spend to get by during litigation. Much lower. They can spend anywhere easily up to 30% interest rates to borrow to get by. And it's much lower than an investment rate of 12%. Why? Because it's simple interest. It's simple interest, 1% per month, period. And so it is so much lower than when you invest at 12% and you get the compounding. It's not an outlier. There are at least a half a dozen states that have been that have interest rates, some above, up to 15%, some slightly below 10%.
So let me just do that for you for a second.
Sure,
So
Your Honor.
what if it were 1% rather than 12%? Would you be arguing the same thing?
If 1%?
Yeah, I mean,
if the
instead
interest
of you had
rate
a
were 1%, unfortunately for my clients, then it would be hard for me to argue that that was irrational. This is a legislative decision. In fact, until this hearing, I have never heard of any court ever telling a legislature your interest rate is unconstitutional. For the first time today, I heard that there was a trial judge in Illinois who made a similar decision. I know nothing about that case, but I can tell you I am aware of no published decision, no appellate court ever saying to a legislature, we don't like your interest rate, change it. And if there were one, I know my esteemed brother
But again,
would have found
just to
one.
push you a little bit.
Yes, Your
'cause-
Honor.
So any interest rate the legislature sets is okay. Either a really low one or a really high one because of these factors. And I thought your factors are good. It's simple to calculate. It doesn't fluctuate with the times. So again, 30% works, 1% works, 0.0001% works, anything works?
I've given a lot of thought to that question, Your Honor. Let's say that the legislature imposed a 200% interest rate. I'd be in a tough position to stand here and call that rational. And this court would be in a tough position to figure out what to do about it. And what this court has done in situations where something is that completely outrageous would probably be to say to the legislature, this sounds out of bounds, and at some point you got to fix it, because courts don't jump in. This court should not jump in and decide what to do about the interest rate. But that's not this case, because 12% is totally within the bounds of a rational and reasonable interest rate. It's similar to Hawaii, New Mexico, Rhode Island, Connecticut, Vermont. It's not, we can't all of a sudden now tell all of these states that your interest rates are wrong and Massachusetts is wrong. It's just not an irrational statute. Could there ever be a point? Minus 10%? Sure, Your Honor. But that's not this case. I'll just close it out with quoting this court. The legislature's decision to maintain the 12% rate in tort judgments against private parties, despite fluctuating conditions, is undoubtedly its prerogative. That was in the Secretary of Administration case that we've both cited.